Hi, my name is Josh Blackman. I'm the president of the Harlan Institute, and today we are honored to be hosting the final round of the Harlan Institute-ConSource Virtual Supreme Court competition. We are deciding today the case of Zivotofsky v. Kerry. We have before us two teams who have been advancing through all the different rounds. Representing the petitioners are David and Nick from Montgomery, Maryland. Representing the respondents will be Ammas and Max from Oswego, Oregon. They will each have 20 minutes to make their arguments. Okay? Petitioners, whenever you're ready, you may proceed, and I understand you want 5 minutes of rebuttal time?
That's correct.
Okay, Counselor, you may proceed whenever you're ready.
Thank you, Justices Blackman and Silverbrook, and may it please the Court. My name is Nick Gameth, and I'm appearing on behalf of the petitioner, along with my co-counsel David Ademo. The crux of this debate can be traced back to Article 2, Section 3 of the Constitution, which provides the President the power to receive foreign ministers and ambassadors. The respondents have argued that Article 2, Section 3 implies that the President also has the power to unilaterally recognize foreign nations. However, when we examine the historical context of this part of the Constitution, it's clear that the power to receive ambassadors is a narrowly construed duty provided to the President solely for logistical reasons. In the Articles of Confederation, this power rested with the legislature, which had the adverse foreign policy consequence of requiring the legislature to gavel into session every time it was to receive an ambassador. So, when the framers began to formulate a new constitution, they transferred this duty to the executive to avoid such inconveniences. Structurally, the Constitution makes all other foreign policy questions a shared responsibility between the executive and legislative branches. For example, Article 1, Section 8 of the Constitution gives Congress the power to declare war, while it is the executive who is primarily responsible for the conduct of the war. Whereas the President may negotiate treaties, it is the Senate's prerogative to provide consent. And although the President is the commander-in-chief of the military, the Congress is responsible for funding and providing for an army and a navy.
Counselor, can I ask you a question? So I acknowledge that the power to receive, or the duty, as you say, to receive ambassadors is clearly in Article 2. How is it coextensive with recognizing foreign sovereigns, though? Or how is it not?
Well, we believe that there is some inherent overlap between the two powers, but we don't believe that the Article 2, Section 3 is explicitly giving the power to recognize foreign nations. We believe that the power is shared, and that other parts of the Constitution bear that out.
Okay, great. Thank you.
So, Counselor, if I can piggyback on Justice Silverbrook's question, where is the recognition power even defined anywhere in the Constitution? Where do we even think that Congress has a role in this authority?
There's nowhere in the Constitution that explicitly gives the recognition power to either branch. But when you look at the conduct of foreign affairs, it's split between the two branches, and just in the same sense that receiving a foreign ambassador would imply recognition of a foreign nation, so would, for example, the declaration of war that's provided to the Congress. So we believe that although it's not explicitly mentioned, it's implied that the recognition power goes hand in hand with powers that are delegated to the legislature and the executive, so it's implied that it belongs to both branches.
Could you give some example? I'm sorry, go ahead, please.
Well, let me just ask a clarifying question, which is, let's say we agree with you, right? The Constitution does give separate foreign affairs powers to Congress and the executive. What power does Congress have that directly involves it with the recognition process? They don't have, right, there's no section of Article 1 that talks about recognizing a foreign government or receiving ambassadors. Where does that power for Congress come from?
Well, we believe that, like we mentioned, it's the power to recognize foreign nations is implied in a number of duties that the Congress performs. Again, declaring war, for example, would be an example I could think of where by declaring war, the Congress is thereby recognizing that nation. But we don't believe that power is explicitly stated anywhere or given to either.
But if we declare war against ISIS, right, we're not recognizing ISIS as a foreign sovereign, are we?
Well, I believe we are recognizing that it is a foreign entity. I don't think that the power to recognize foreign nations is explicitly given anywhere.
So to follow up on Justice Silverbrook's question, when both houses of Congress issue a declaration of war, right, say against, let's just say one day Congress declares war on Israel, right? And they specifically say we are including Israel and Jerusalem in that declaration of war. Would that act of recognition be allowed under Congress's powers?
I believe it would. I believe it would. I believe, again, I don't believe there's any structure within the Constitution to formally recognize nations. There's no process for doing that. I believe the recognition of nations is inherent in some of the duties of Congress. So I believe declaring war on Israel and including Jerusalem in that would be, in effect, would be recognizing Jerusalem as a part of Israel. But again, there's no definitive recognition. There's no process within the United States government that we believe officially would recognize one nation as legitimate or one nation as illegitimate. It's implied through the different policy choices made by both branches.
Okay, proceed, councilors.
There are other clauses in the Constitution as well that are even more incontrovertible when it comes to this case. Specifically, we believe that the issue at hand as it relates to a U.S. citizen's passport is inherently a question of foreign commerce. So technically speaking, passports are articles of foreign commerce between the United States and foreign nations. And thus we believe that under the Foreign Commerce Clause, Congress has explicit authority to dictate this policy.
Is a passport actually commerce, though? I mean, we're not talking about the movement of goods or transactions. We're talking about little pieces of paper that allow people to go between countries. How is that commerce?
Well, we believe it does connect to commerce in various ways. The travel of citizens from one nation to another has a number of inherent implications for the economies of the two nations, and therefore there's a number of in that sense it is very much an issue of foreign commerce.
What other clauses of the Constitution do you think support your case?
Well, there are a number of other clauses. For example, under Article 1, Section 9, Congress has the power to provide for a uniform rule of naturalization. And in Section 214B of the Act that's under consideration in this case, Congress allows a person to request that on their consular report of birth abroad, their places were to be listed as Israel instead of Jerusalem. Since that consular report of birth abroad is an article through which a person can be naturalized, we believe that it would be under Congress's power to provide for a uniform rule of naturalization to regulate the content of such report. In addition, the necessary and proper clause allows Congress to legislate based on powers that are granted to any department or officer of the government of the United States. And because the Secretary of State has been empowered by Congress to issue passports, Congress has the authority to direct the Secretary of State to perform certain actions relating to that passport.
But Counselor, let me ask you a question. Counselor, let me ask you a question. In a case which I'm sure you've read about called United States versus Curtis Wright, the Supreme Court said that the President is the sole organ of foreign policy, that the President of the United States speaks with one voice. How can the United States speak with one voice on matters of foreign policy if, the United States President saying Israel does not contain Jerusalem, and we have this document of the government saying, oh yes, Jerusalem is in Israel? How can the United States speak with one voice in this respect?
Well, I have 2 points regarding the Curtis Wright case. First of all, Justice Sutherland quoted John Marshall saying that the executive is the sole organ of foreign relations. However, that quote was taken out of context. John Marshall was referring to a treaty of extradition, and what he was implying is that the executive is the sole organ of government involved in executing a treaty. He did not mean to make a sweeping statement about the structure of our government. Secondly, in Curtis Wright, President Roosevelt was acting under a grant of power from Congress, a delegation of authority, and so his power was at its highest to quote Justice Jackson in the Youngstown case. However, in this case, the president is acting where his powers are at its lowest ebb, acting in direct contradiction to what Congress has instructed him to do. And so this case differs in many ways from Curtis Wright, so we don't believe that it controls the
Okay, proceed, Counselor.
We can also point to several historical. We can also point to several cases in our nation's history where the executive has acquiesced to Congress's will in the matter of recognition. For example, in 1995, Congress passed the Foreign Relations Authorization Act, which, very similar to the case before us today, instructed the Secretary of State to permit places of birth to be reported as Taiwan instead of China. This part of the Foreign Relations Authorization Act contradicted the executive's policy of having one China and not recognizing Taiwan as a separate entity. However, after Congress passed the Foreign Relations Authorization Act, the President and the Secretary of State changed their regulations to acquiesce to this goal. And so we believe that that clearly demonstrates that Congress has primacy in this matter and that the executive can only act when Congress has not made a statement to the contrary. And we believe that that's in keeping with clear precedents set in the Youngstown case.
So, Counselor, could you go back and maybe address some of the precedents from the early years of a republic, starting from the time of the founding and the framing of the Constitution, of how the founding generation viewed this recognition power?
Certainly. So there are cases, for example, President Washington's recognition of the French revolutionary government, or even the recognition of the state of Texas. However, what's key to note in that case is that just because Congress didn't act to stop the executive from recognizing one government over another, doesn't mean Congress agrees that the executive branch has the power to unilaterally recognize. All that it does mean is that Congress agrees with the policy objective of recognizing one government over another.
But didn't Washington simply accept the minister from France, and I don't think he checked with Congress first before he did that, did he?
No, he did not. But that doesn't change the system of separation of powers that we have in our government. Just because Congress fails to act every time the executive acts in a way that is unconstitutional doesn't imply that a practice suddenly becomes constitutional.
Sorry, go ahead.
For example, if we refer to the amicus briefs filed in this case, the Senate and the House of Representatives both have made it clear that they don't believe the executive has a unilateral ability to recognize a nation. If Congress agrees that it's a good idea to recognize one country to recognize one government over another, all that means is that they agree with a policy objective, not the method through which that is. We can also, we also would like to address the political consequences of such a decision. The respondents in this case have talked a lot about the potential adverse foreign policy trouble in the Middle East, for example, conflicts regarding our allies. However, this court is not competent to address the political implications of a case such as this. When this case first came up in 2011 in Zivotofsky versus Clinton, Justice Sotomayor made it clear in her concurring that while this is a case that the court could address, it had to steer clear of delving into certain foreign policy.
Well, Counselor, let me, if I may ask you a question that's related. You have about 1 minute left. I'll make the answer quick. What if this decision results in the death of Americans? What if, people start rioting in the streets and, blowing people up and shooting people and people die? Why should the court make such a ruling?
Well, we believe that it's not the court's place to take these sort of considerations into account when making a decision. This is solely a constitutional question as to whether or not the Senate or the Congress has any role in the recognition of foreign nations. We believe it's not the role of the Supreme Court to be taking into account these considerations, first of all, and second of all, we don't believe that the Supreme Court can definitively say what the adverse consequences of this ruling in one way or another might be.
Okay, Counselor, you have a minute left if you want to offer a summary.
I'm going to reserve it.
We would like to add that on to our rebuttal time.
Okay, you can do that. I'll give you then 6 minutes for rebuttal. Okay, please put your computer on mute, and we will gladly turn the microphone over to our friends from Oregon, Ammas and Max, who will be arguing on behalf of the respondents. Counselors, you have 20 minutes whenever you're ready.
The question of whether the president's recognition power is subject to control by the Congress, the answer is a definitive no. Due to the extensive precedent, the presidential recognition power and historical ratification of the specific authority is apparent. And looking towards the implications of the overarching power in the specific case of Zivotofsky v. Kerry, the very question of legitimacy is rooted in the creation of Israel as an independent nation, and any encroachment upon the president's authority in this regard would be an encroachment upon Israel's statehood. The implicit power is illustrated in Article 2, Section 3 of the Constitution, with the president's power to receive ambassadors and other public ministers. The clause declares the duty of the president and naturally extends to the power to clarify the legitimacy of governments and their subsequent boundaries. The president's recognition power for the greater portion of the 20th century was clear, with notable examples including Taiwan, Cuba, and Israel. The power itself is embodied within the Constitution, with founders believing in the president's sole power to declare the official list of recognized foreign entities, dating back to the French Revolution. No specific powers of congressional recognition are implied in the Constitution, whereas the president and post-liminary executive is charged with operating upon the principles of weighing the interests of the United States while obeying laws enacted by Congress when dealing with foreign nations.
More specifically, in regard to some of the claims that we believe were brought up by the petitioner, they make a couple of claims about how declaring war is to some extent similar to recognition, or how in this circumstance we see that Congress has power over foreign affairs in this instance. We'd like to have a couple of responses to this. First off, they make a couple of statements about how this means that Congress can lead to war. We'd like to indicate that first off, the president has the power to veto an act of war. So in a situation where the president believed they were recognizing that an act of war would recognize a nation, they would have the ability to veto this action. Additionally, they kind of try to bring up this argument about how a passport must be considered commerce because it has it is by effects and is part of regulating international trade. We have a couple of responses to this. First off, by effects, most things are related to commerce. This doesn't mean that Congress has power over most things. The majority of freedoms that we exercise in the United States does in some way come down to our interactions with capital or our exertion of material wealth. This doesn't mean that Congress has the ability to mandate everything we do. Additionally, in the case of PEG 80, what we're seeing is that the Supreme Court has previously ruled that there are situations where the president is able to veto giving a passport to an individual or suspend this identity of the passport for political or political reasons or for reasons related to national security. So in this instance, we believe that the president PEG 80 is beneficial in regards to our advancing forward.
Counselor, let me ask you a question. Is allowing, in this case, the parents of Mr. Zivotofsky to list on their passport that their son was born in Jerusalem, Israel, rather than Jerusalem, truly an act of recognition anyway? I mean, is this really interfering? Even if we say, okay, maybe the president has exclusive recognition power, is this really an invasion of that?
Well, ultimately, what we have to recognize is that the current executive and administrative branch of the nation has gone ahead and continued the trend of recognizing Jerusalem as an independent entity that is not located in Israel when it comes to sovereignty. And what we see is if Congress wins on this regards, we're seeing Congress forcing the president to contradict themselves and pass administrative governments over this policy, and that contradiction is really going to the core of the real issue that we're seeing. And as respondents, we have to go ahead and go against, because if you create this contradiction within the executive, you're ultimately saying that the president is no longer the sole speaker for the country, and by taking away the sole power for the president, this is hugely impactful for the power of the president and also the power for the president to take unilateral action and represent our country as a whole. Regarding this,
so, Counselor, if I can interrupt briefly, you also referenced, I'm guessing, the Curtis Wright case, which your friends from Maryland did, the sole organ case. And they seem to suggest that Curtis Wright, that language was actually kind of dicta, that it actually wasn't controlling, and that the United States is not the sole organ. I'm sorry, the president is not the sole organ, that Congress does have a shared role. How do you respond to that argument that in many respects Congress does have some role in foreign policy? They can declare war, they can issue trade embargoes, right? They can decide to punish states and not do business with them. I mean, Congress does have power that the president doesn't necessarily get to override.
So to respond to that, if you look to the case of Youngstown Sheet Co. and Tubing versus Sawyer, we see that it was decided by the Supreme Court that the president's assertive power in this regard is exclusive but also conclusive. So we see that there is a role for Congress, but Congress does not hold the power, as we're stating, to go ahead and infringe upon the executive's executive decision in this regard because of the contradiction that it is creating. This contradiction is going to the root of the problem, as we see that it's infringing on the executive's consistent decision since the Truman administration to withhold recognition. And if we also look at the decision in Nixon Administrative of General Services, this is also going and reversing that decision as well. So by placing precedent of all these cases, we see that there is a role for Congress, but in this specific Congress, we've seen the Supreme Court consistently ruling on the side of the executive.
But Counselor, I still want to go back to my question, which I'm not sure has been answered, which is Congress passing a law with respect to individual passports, right? The small number of American citizens who are born in Jerusalem every year, right, allowing them personally list on their passport that they were born in Jerusalem, Israel, rather than just Jerusalem. Is that really an act of recognition? Is that really interfering with the president's power of recognition?
Well, in simply dealing with the fact that the way we go ahead and conduct commerce, as brought up by the petitioner, as well as how we recognize individual citizens and their sovereignty in which country they belong to, is conducted through passports. We see that if we allow even the small number, approximately 50,000 people, to have this change on their passport, what we're effectively telling not only these people, but the rest of the international community is the United States has decided upon Jerusalem and which state has the rights over Jerusalem and its sovereignty. And it's not only the implications for these 50,000 people, but all the people around the world who will now take this decision and use this decision in dealing with the United States and stating that the United States has simply gone ahead and decided upon the sovereignty of Jerusalem and Israel.
Perhaps more specifically, that might sort of answer the question much more directly. First off, President Bush has already released a statement on this, saying that that actions such as the Jerusalem Embassy Act impermissibly interfere with the president's constitutional authority. To this extent, we're going to see that presidents and previous executive powers believe that this has an interference. Additionally, it doesn't really matter how many people are recognized. It matters the fact that every single person that can be affected by this is affected by it.
But there's, Counselor, there's clearly a difference between establishing a U.S. embassy in Jerusalem rather than Tel Aviv. That's materially different than allowing a couple of individuals to put on their passport Jerusalem, Israel, and foreign policy with respect to Jerusalem doesn't change otherwise, right?
No, we don't agree with that statement because effectively what the United States is doing is still the same. Though the physical entity within an embassy is not being created, we don't see that being the issue. We see the issue being the overarching message and foreign policy that the United States is reinforcing. And though we don't believe that this is clearly a political issue, that this has the ability to hinge upon the consistency of foreign policy conducted by the president in regards to national security is where the issue lies.
Okay.
So what if you did a compromise, right? What if you stamped in the passport that the person was born in Jerusalem, Israel, and put a little asterisk, like a little star, and say, by the way, the United States does not recognize Israel as including Jerusalem. Why can't you just do that?
Well, this would be a political compromise, but at the point of the law that's been brought forth in Zivotofsky v. Kerry, which is specifically responding to Section 214A of the Foreign Relations Authorization Act, what we're saying is that the wording of this doctrine that the Supreme Court will either have to endorse as constitutional or not constitutional has serious implications. It specifically states that the Congress maintains its commitment to relocating the United States Embassy in Israel, Jerusalem, and urges the President, pursuant to the Jerusalem Embassy Act of 1995, to immediately begin the process. What this means is that if the Congress rules If the Supreme Court rules that the way in which Congress has been acting is constitutional, they are allowed to do this, or the way in which the President has been acting is constitutional, that he is allowed to do this, this means that this law would have to be published by the letter by the President, which would mean that we would have to put the embassy in there. We wouldn't be allowed this political compromise because this isn't the President's being set forward. This might have been something that we could have done before Zivotofsky and Kerry was brought forth, but perhaps after Zivotofsky and Clinton, or perhaps even before this occurred. The point in which we are at in this process has much greater ramifications.
Okay, so Council, let's move a little bit past the embassies, and let me ask you another question, right? What happens if Congress passed a law that said we will do business, we will allow specific types of trade with Jerusalem, the capital of Israel? That's all the bill said. We will allow specific types of trade with Jerusalem, the capital of Israel. The President vetoes it, and Congress overrides that veto. Would that law be constitutional?
Well, according to Hague v. Agee, this sets this legal precedent. The President does have the ability, in regards to foreign relations, to have executive control over anything that could have an issue on national security, because the way in which the President acts in some situations seems to be cloaked or somewhat secret in regards to the state of the nation as a whole. So in the instance where the President believed that this could have a massive implication or ramification for foreign relations with the state of Israel and Palestine, we would see that Supreme Court would indicate that this is a constitutional action for whom we veto it. Secretary of State John Kerry actually indicates that he and the rest of the administration believe that the current political strife and ordeal occurring in Palestine and Israel has massive implications.
But that hasn't changed, right? So that's not different than when President Bush signed the law, right? Why not just veto? If he disagreed with it, why not veto?
I'm not entirely sure why Bush chose to act the way he did, but he did explicitly sign a statement when he signed the bill that said if this was construed as anything other than a suggestion, he would deny it and he would say that it was not constitutional. Additionally, if you look back at Section 214A in the verbiage there, it says that the Congress urges the President pursuant to the Jerusalem Embassy Act of 1995 to follow these policies. An urge is different than a commandment. If I urge you to stand up, you don't have to. If I tell you that you have to stand up, there's a different implication there. So Bush probably just read it and assumed that urge meant ask.
And by the way, John Kerry, as a senator, actually voted for the very bill he's now opposing, so he was for the bill before he was against it. Counselor, if I can ask another question, what role should the court consider of international community? Should we care at all what the international community thinks about this decision, or should we consider what impact this may have on national security when we're ruling on this matter?
Well, really, what our case boils down to is not the importance of the justice system and specifically the Supreme Court taking into account the international ramifications, but rather taking into account the ramifications on the President and the executive powers we see in government and how their relationship with foreign nations is directly impacted by this ruling. The question is not whether or not we see issues arising in Israel and Palestine over this case, but the question is, do we see issues arising with the executive's ability in talking with these nations? And that goes directly to the Constitution, and that's where the court is called into question over Article 2, Section 3, in which we see the power of recognizing ambassadors and receiving them. This power, at the time being, was the only way we saw diplomacy occurring for the United States. And if you look at it in a broader sense today, where we see more diplomatic negotiations taking place, but all through the executive once more, we have to recognize that the Constitution has the ability for the President with the sole recognition power, and nor in the Constitution does it specifically mention Congress. So to go against this is where the question lies, and we believe going against this would be going against the Constitution in itself.
So, Counselor, your friends on the other side mentioned a law involving Taiwan, and that Congress had a significant role in the recognition of Taiwan, whether it's part of China or not part of China. Can you please discuss the relevance of that precedent, please?
So in regards to what Nixon did and kind of the shadow diplomacy that occurred during the Cold War, what we're saying is the congressional authorities are essentially the ability for Nixon to go and negotiate in secret with Chairman Mao in a situation where Congress had no authority to dictate or control the way in which he was acting is an important precedent to look upon. This idea that he's been allowed to unilaterally make foreign policy decisions when the possibility of national security or foreign relations are at risk, and the fact that Congress did not declare this an unconstitutional use of power, that Congress did not sue the President for essentially making peace with China in this situation. What we're saying is that we have instances in which the president has acted unilaterally and has been lauded with success. Like Nixon's legacy would have been much better, not if we don't look at Watergate. But I mean, what it comes down to is this idea that what he did was seen as tremendously beneficial by the majority of the American people. Like this was seen as a good thing, like a good use of power. His ability to make peace with a country that was trying to essentially pitch the world into thermonuclear war, along with Russia and us, was a good thing.
And to go back to the point in which we see that being so important, having this power directly in the executive is because of the unilateral action we saw results with China and Taiwan. If this unilateral action had not been taken, and if this action is taken away from the executive, we see instances in the future, or even this instance, turning out much differently, and a world turning out much differently when we see power is not vested in the president, and the country no longer has one sole voice and the ability to get things done for the nation.
Okay, can you tell us a little bit about how the first couple of presidential administrations, some activity involving recognition, supports your argument?
So going back to the first presidency of the United States and also looking towards the Articles of Confederation, what we saw with the Articles of Confederation that more power was vested with Congress in dealing with foreign nations, and ultimately if you look to the success of the Articles of Confederation, the fact that we no longer use them, you can see that the Articles were lacking in their ability to have a sole unified power. And going off of that, if we look at the presidential administration of George Washington and dealing with France, we saw the president having the ability to recognize ambassadors, and in doing so, recognize the entire country, the sovereignty of the country, and not a strict singular political movement. So if we look to that example, we look to the strife and the war and conflict that was occurring in France at the time with the French Revolution, we see that the president had the ability to take action that did not recognize a sole individual or sole government, as we're seeing with the issue of passports once more. We saw him recognizing the entirety of the country. And any implications or any individual going against the president in this regard, once again, could have turned out much differently for the relationship between the United States and France.
Okay, thank you.
You have about 3 minutes left. You can continue using your time.
Well, basically, if we want to finish off just on a small conclusion, what we see is the president's authority with foreign relations and diplomacy is directly within the Constitution, whereas Congress does not have any direct verbiage within the Constitution that goes to the root of what foreign recognition is and whether or not the Congress has foreign recognition powers. Going beyond that, if we also look at the precedent in which we've seen, with the Supreme Court already, we can look at cases such as Williams v. Soko King, U.S. v. Belmont, U.S. v. Pink, Barco Nacional de Cuba versus Sabino, National City Bank of New York versus Republic of China, and U.S. v. Curtis Wright, all reinforcing the idea that the executive has the power to go and recognize foreign diplomats as well as the sovereignty of foreign nations. So with the historical ramifications of that, in the precedent, as well as the historical ramifications of past presidencies such as George Washington, Truman, and Nixon. And also looking at all of this, we see that the president has been given this authority in the past, and ultimately what we see, as my partner brought up, is this recognition power has been used for the sole purpose of furthering the interests of the United States, both in issues of national security and also the overall well-being of United States citizens. And then the dangers that we see that we really have to address, the idea of not having a sole entity and a singular power that is speaking for the entirety of the United States. And when we see that occurring, we're going into dangerous territory where we see a more political atmosphere and an atmosphere in which we see the United States not being able to recognize nations unilaterally.
Any action that impinges upon the president's ability to negotiate foreign relations that would indicate that individuals in the United States are not able to life, liberty, and the pursuit of happiness, anything that impinges on the president's ability to maintain a state of peace and a state of equality for as many people as he can is something that should not be allowed to happen. The situation that we're seeing is that allowing these passports to be marked with Jerusalem has the chance of helping a minority but hindering a majority and saying the Palestinian-Israel conflict spiraling into something worse than it is currently, and the situation that we can already agree is not favorable.
So with that being said, to just wrap up, not only are the political implications tremendously difficult in this regard, but we also see this to be a direct violation of presidential power and how we've seen this presidential power through precedent and going directly against the Constitution.
Okay, Counselor, thank you very much. I'm going to put you on mute so we don't hear any feedback. Nick and David, whenever you're ready, you may proceed. You have 6 minutes remaining.
Thank you. Much of the respondents' argument today hinges on the parade of horribles they claim will come to bear before it finds for the petitioner today. They use words such as political implications. The respondent claimed adverse foreign policy consequences, including turmoil in the Middle East or strife in Jerusalem. This court cannot be certain of those potential consequences, but this court can be certain of one thing, that for the entire history of the Supreme Court, this court has refused to judge political questions or political consequences. The court expressly examined the question of political consequences when it took up this case in 2011 with Zivotofsky v. Clinton, and it made clear that the court would not in the future delve into the foreign policy implications of the case. The court 4 years ago stated that they would only examine the constitutional and legal issues. The court can render legal judgment on what the Constitution intended, but the rest is correctly left to the elected political branches of our government, which will deal with the foreign policy consequences if they have.
But counsel, if I can interrupt you for a moment. Of course, it's true this court isn't going to decide the case based on how foreign policy people perceive it. But shouldn't we be looking to how Congress and the President have interacted over the course of nearly 2 centuries? I think your friends in Oregon made the point that Congress, regardless of original meaning, right, regardless of how the Constitution was originally designed, Congress has acquiesced to a very robust understanding of the executive recognition power. And this may be the first time in American history where the Congress tried to go around the President in such a manner. I mean, shouldn't we be looking at how Congress acquiesced in deciding this sort of issue?
Well, Your Honor, I don't agree with the premise that this is the first time that Congress has disapproved of the executive's actions, and Congress has not acquiesced in the past. We brought up the example in 1994 of Taiwan, in which Congress expressly contradicted the executive's standing one China policy and enacted Section 187 of the Foreign Relations Authorization Act, which required that the Secretary permit Taiwan to be listed as a place of birth. The respondents mentioned signing statements before, and President Clinton issued a signing statement on the Foreign Relations Authorization Act as well. In that signing statement, he disputed 4 parts of the act, but what he did not dispute was Section 187. The fact that the President would dispute constitutionality of many things, but not the section requiring him to write Taiwan as a place of birth, implies that he recognized that Congress is the superior power in this matter.
If I could add on, we believe that deciding in favor of the respondent in this case has a number of negative ramifications for our democracy. Our opponents, the respondents discussed the dangers of the politicization of foreign policy should the court rule in favor of the petitioners. However, we believe the bigger danger is in providing undue power to the executive without sufficient checks and balances to the legislature. We believe that truly that ruling in favor of the respondents would really cripple the separation of powers that are so crucial to our democracy. It would create a dangerous precedent to provide more and more foreign policy powers to the executive with cutting out the legislature from the loop.
Counselor, can I ask you a question? What does the balance of powers when it comes to recognition look like in your scenario? You seem to be suggesting that Congress actually has more authority in this context than the President. Tell us what that scheme would look like.
Well, we do believe that Congress would have more authority, and there's actually a quote that I trying to find for you. One of the framers essentially said that the primary authority over foreign policy should be delegated to the Senate, with the President was intended to be more of a support system, more of a balance on the Senate. In fact, I believe the the Constitution originally had treaty power solely given to the Senate. They added the president as a check on the Senate later on. We believe an ideal scenario would be one in which the Congress does have some ability to.
Well, Counselor, I have some issues with what you've just said, though, right? So the president makes treaties, and then it's ratified by the Senate. How is that the president doing a check on the Senate having the primary role in treaty making?
During the debates on the ratification of the Constitution, the convention's scheme in which the Senate has sole treaty power to scheme where the President and the Senate were co-equals in the foreign policy world. And that isn't just something that occurs with treaties, it also occurs with the confirmation of ambassadors to other countries. The Senate can reject a nomination for ambassador, and that has implications for the recognition power as well. The recognition power isn't just the 8 words in Article 2, Section 3 that allow the president to receive ambassador. The recognition power is also contained in the words that allow Congress to declare war on a sovereign state, and it's implied in the words that allow the Senate to decide whether or not they will send an ambassador.
But Counselor, you seem to be saying 2 different things, though. On one hand, you're saying they're co-equal, so they should each have some role to play in recognition. But then before, you said, well, actually, Congress has more authority than the president in this context. Which one is it?
Congress and the president are co-equal, but Congress can be seen as having the final say because Congress can decide whether or not to agree with the president. The president cannot go around the Congress and, for example, send an ambassador to a country when Congress has explicitly said, no, we will not prefer this ambassador.
But can't the president just veto Congress's legislation? Isn't that a check on their power over recognition? I mean, that could have been what happened in this context.
The president could veto a joint resolution from Congress. However, our basic position in this case is that the president can only act when Congress has not spoken. If there is a duly enacted law, as there is in this case, the Foreign Relations Authorization Act for 2003, and as there was in 1994 with the Foreign Relations Authorization Act, if such a law is in place in the United States Code, then the executive may not contradict it. That's what the court said when it decided Youngstown Sheep versus Sawyer, and it's in the Constitution that the executive must faithfully execute the laws. That's our entire argument.
Okay.
Okay, Counselor, and you have about 30 seconds left for a closing statement.
Sure. I would just like to mention again how the respondents have brought up concerns about the implications of the ruling in our favor in this case, and concerns about the foreign policy implications. I'd argue that the bigger negative implications that we should be worried about is how the world will see our decision as crippling the strongest democracy by taking away very important protections that balance power between multiple people and made our democracy a model for countries around the world. So I believe it would set a very dangerous precedent to argue to rule in the favor of the respondents in this case. And thank you very much.
Okay, and that brings our proceedings to a close. I will thank each and every one of you. Both teams performed spectacularly, and we at the Harlan Institute are so proud of you for taking the Constitution and the Supreme Court so seriously. And we are extremely impressed with the amount of preparation and care that you brought to these arguments. We will be announcing the winners later today, and we hope to see you soon in Washington, D.C. for Constitution Day. Julie, is there anything you'd like to add?
No, I'm just going to add that we will very much so looking forward to having at least one team, right, or really only one team, at ConSource's Constitution Day celebration, which will be around September 17th of this year. And I just wanted to reiterate what Josh said. You guys were excellent. Both teams did very well today. You should be very proud of yourselves. And now, if you haven't already done so, I do recommend that you read how the court ruled in Zivotofsky v. Kerry. The opinion is available at supremecourt.gov.
And several of the questions I asked came straight from Justice Thomas's dissenting opinion, so you will see where my material comes from. All right, and with that, I will adjourn court. David and Nick, thank you so much. Max and Ammas, thank you so much. We will be in touch shortly, and the case is submitted. Thank you.